block light, encroachment and roots causing subsidence. What are your rights if you're unhappy about your neighbour's trees and shrubs, and how do you enforce those legal rights? In this video, I'll explain the steps you can take if branches intrude on your land and your right to light, and how to deal with problem roots. I'm Daniel Barnett, a barrister practicing in London, and I'm the presenter of the Legal Hour on LBC Radio. Always speak to your neighbour about your concerns before taking any further action. A calm approach can help to prevent a disagreement turning ugly or even turning into a legal dispute. If you're uncomfortable speaking face to face, sending a respectful letter, make sure it's respectful, might do the trick. But of course, a softly approach isn't guaranteed to resolve an issue, and you may need to rely on the law. Branches that overhang your property are one of the most common causes of dispute. The basic rules on the issue are set out in a House of Lords judgment, Lemmon and Webb, from 1895. This established that where branches intrude onto your land from a neighbouring property, you're entitled to cut off the overhanging foliage without consulting your neighbour, although obviously it's best for the sake of neighbourly harmony to consult them first. You can't force the neighbour to cut the overhanging branches themselves, but you are entitled to do it as long as you don't trespass on their land while doing so. Now, the plant doesn't become your property, the branches don't become your property in legal terms. Your right is simply to abate the nuisance, as it's called, caused by the overhanging. This means you're not entitled to keep the branches or any fruit on the branches, and should offer the severed branches to your neighbour. You shouldn't dispose of them unless the neighbour has agreed. You can throw them back over your neighbour's fence, but again, that is confrontational. An exception is where the tree is within a conservation area or subject to a tree preservation order. That might stop you undertaking work without obtaining local authority permission. Most councils maintain an online register or a map of conservation areas and TPOs, tree preservation orders. Check this if there's any doubt about the status of the tree. If the tree is covered, you've got to get consent for cutting any branches by applying to the local authority. You can do so by making an application through your local council's planning portal. You'll need to detail the work you'll undertake and give reasons for it. What if a neighbour's tree or hedge is so high that it's blocking out the light? If your home has received light through its windows for 20 years or more, it probably has an easement of a right to light under the Prescription Act 1832. An easement is a right that benefits your land, requiring something to be done or not done on adjoining land. Where plants from neighbouring land mean that light is inadequate, you could go to court to force the owner to prune plants back or remove them. Now, the difficulty is establishing what counts as sufficient light. It isn't enough to show that there's simply less light available than there was before the plant grew or was planted, and there's no exact scientific method for establishing whether a window receives enough light. The key test, as confirmed in cases including Ough, I'm not sure how to pronounce it, Ough and King, is this: is there such a deprivation of light to render the house or building less fit than it was before? The court judges this in accordance with the ordinary ideas of ordinary people. The obstruction of light has to interfere with ordinary occupations of life. But the Anti-Social Behaviour Act 2003 does ban some excessively tall hedges, whether they reduce light in your home or garden or not. First, the hedge has to be, quote, a barrier to light or access. Second, the hedge has to be formed wholly or predominantly by a line of 2 or more evergreens, including trees, shrubs and semi-evergreens. Third, it must be over 2 metres above ground level. If the existence of gaps at a height of over 2 metres significantly affects its overall effect as a barrier, then it may still be permitted. Finally, it has to adversely affect your reasonable enjoyment of your home or garden because of its height. If the hedge meets this test, you can apply to your council to issue your neighbour with a remedial notice. This requires the hedge to be trimmed. The council can reject your complaint if it doesn't think you've taken reasonable steps to resolve the dispute yourself. There's generally a non-refundable fee. It's more than £400 in most cases, though you might qualify for a reduced rate if you're on a low income. According to the case of McCombe and Reed, the same basic rules apply to encroaching roots as encroaching branches. You're entitled to cut back the roots to the boundary line between your neighbour's property and your own, but you could still be liable for damage caused to the plant. Badly carried out root removal can cause tree decay. You could be liable for the cost of any remedial work needed to restore the tree to health. So consulting an arboriculturalist is likely to be a good idea. If the tree is covered by a tree preservation order or is located in a conservation area, you must get permission from the local authority before cutting back any roots. What if a neighbour's tree roots have caused your home to subside by sucking up water from the ground? You may be able to claim damages and force them to remove the trees. To do so, you've got to be able to demonstrate that the subsidence was caused wholly or partly by the neighbour's roots. As the House of Lords case, Delaware Mansions and Westminster confirms, your neighbour must have known about it or ought to have known about the encroachment. The risk that it would cause damage must also be reasonably foreseeable. I hope you found this video useful. If you did, you might also be interested in this one and this one. Thank you so much for watching. I'm Barrister Daniel Barnett. Bye bye.